Hello, my name's Chris Thorsness. I'm a member of Bond's collegiate sports and higher education practice groups. During today's Business 2023 podcast, I talked about Title IX and transgender athletics. Participation of trans female athletes is a hot topic in the conversation around women's sports these days. There are concerns about unfairness to cis females, including things like shared showers and hotel rooms, versus the benefits of sports participation in combating depression and suicide risk in trans youth, and the invasiveness of gender verification procedures. And then, of course, we have this notion of other and open categories as an alternative to trans females participating in girls or women's events. In 2020, the United States Supreme Court ruled that sex discrimination includes gender identity. As a result of that, the federal courts have weighed in and are widely split on whether trans females can compete in girls' and women's events. In addition, over 20 states have enacted legislation banning trans females from girls' and women's sports. At the collegiate level, the NCAA looks to sports national governing bodies' policies, which can further complicate things. Just this spring, the Department of Education issued proposed regulations that allow some exclusions to try to balance interests of fairness while seeking to minimize harm to excluded athletes. Final regulations are expected this fall. You can see here, with no clear direction and many conflicting laws and judicial opinions, schools are left in a quandary and in need of good, sound legal advice and guidance as the law on this subject rapidly evolves. Also today, Nila Sikander talked about what to do when your employee is expecting. That is, the 72% of women who will become pregnant during their working careers, most of whom will plan to work through the final stages of their pregnancy. Nila talked about the various federal statutory protections, including Title VII, the Americans with Disabilities Act, Family and Medical Leave Act, and the Fair Labor Standards Act. She also discussed in detail the Pregnant Workers Fairness Act, which became effective in June of this year. It's very nuanced. It covers conditions not only directly involving pregnancy, but any conditions related to or arising from pregnancy. And it talks about the things that employers may not do, such as unilaterally imposing accommodations or denying employment based on the need for accommodation, or retaliating against employees who take advantage of the Pregnant Workers Fairness Act or who participate in investigations or enforcement proceedings. Nila talked about the proposed regulations that have been issued, and final regulations are expected sometime in December of this year. Finally, Nila spoke about the federal pump law and the New York Nursing Mothers in the Workplace Act, and how they talk about the requirements for lactation rooms or facilities, and generally the employer's obligation to facilitate breast milk collection for nursing infants. Then number 3 on our hit parade today was Seth Gilbertson, who talked about public employee speech regulation in higher education. He laid out the history of this very interesting and complex issue, and the notion that academic freedom has been recognized by the Supreme Court since the 1960s as something of special concern. And he talked about the evolution of the rules intended to balance interests and teachers' interests as a citizen commenting on matters of public concern versus the public employer's right to run its operations smoothly. He talked about the 2000 case, the Garcetti case, where the Supreme Court ruled that statements made pursuant to an employee's official duties are not really protected citizen statements, which of course has led to a lot of concern about limits and retaliation for statements by instructors and professors for teaching and their scholarship on disputed topics. Several circuit courts have carved out some scholarship and teaching exceptions to the Garcetti rules, but there hasn't been real clear direction on about how to do that. Just this year, however, the Fourth Circuit has explicitly said that Garcetti does not extend to speech by public university faculty so long as that speech is related to their scholarship and teaching. Of course, here in New York, we look to the Second Circuit, which has not weighed in, nor has the United States Supreme Court. That's my summary of today's happenings on the Business 2023 podcast. We'll look forward to seeing you again next time.